Hello, my name is Gerhard Fiolka. I'm a professor for international criminal law at the University of Fribourg in Switzerland. And for this 2024 edition of the LPIS V-Law Review on Law and War, I would like to look at the question: what could be the role of international criminal law in armed conflict? So, in the media, in NGOs, in so-called civil society, the effect of international criminal law is very often overstated and overestimated. Very often, people seem to think that criminal law could actually influence the behavior of political or military actors. But this is naive to a certain extent, as it does not take into account the very limited effects of criminal law as such. After all, international criminal law still is criminal law, and it's important to assess realistically what it could actually do. First of all, it's very important to note that criminal law as such does not have any direct preventive effect. It's not even designed to do so because criminal law always deals with the past, with breaches of rules, with wrongdoings that have happened in the past. Criminal procedure never deals with the future, but exclusively with the past. There is no direct influence of international criminal law on behavior of people, the only exception being the incapacitation of detained sentenced persons who will not be able to commit similar crimes while in custody. Because this limitation of the effect of criminal law is often seen as a bit unsatisfactory, we try to build some kind of bridge to the future. And this bridge to the future is the idea of a deterrent effect, so that persons suffering punishments for their acts, as well as the general public, will be afraid of further punishment and therefore refrain from committing punishable acts. In continental European doctrine, this is often described as some kind of negative prevention, which could be individual or also general. The idea of prevention, of deterrence, features quite prominently in political discourse, but also in the jurisprudence of, for example, the ad hoc tribunals. However, there is one problem with that. Criminologists have not been able so far to find any evidence that this deterrent effect of criminal law actually exists. This is, on one hand, due to the fact that the effect of social rules as such and the deterrent effect of criminal law could not easily be separated analytically. In general, it won't be possible to say that people refrain from punishable acts just because those acts would be punishable. It's also possible, and in fact quite probable, that people, or at least the majority of the general public, are not inclined to commit this type of acts because they have no need to do so and judge it as wrong and reproachable anyway. Very often, this deterrent effect, nevertheless, is quite present in people's thinking because they will usually attribute their obeying specific rules to the risk of being punished. But we need to clear about one more fact. I mean, most criminals are not criminal all the time, but only in very specific situations. So, the vast majority of drivers will not park their car somewhere where it's forbidden, as long as there are enough parking spaces available they can use legally. But as soon as there is no parking space available that could be used legally and they have to go to an important meeting, most people will suddenly be inclined to break the rules nevertheless. So very often the breaking of rules is linked to very specific situations and very specific pull factors. This is true not only for domestic criminal law, but also for international criminal law. And here we have some very specific factors that make the situation even more difficult and that put specific risks on the effect or potential effect of criminal law. First of all, we need to note that situations in international criminal law are very often marked by conflicting norms and rules. First of all, some leaders will act out of conviction. They have a plan to change society, to change social rules. And of course, as soon as you're very convinced of what you are doing, the effect of the rule and the perception of risk of punishment will not be very strong anymore. So someone who wants to change the rules and foster social change and legal innovation will most probably not be very much under the influence of the rules he or she precisely would like to change. Furthermore, leaders will not take the risk of criminal prosecution very seriously because they assume that their regime will shield them from prosecution, and very often leaders are precisely leaders because they do not plan for failure. They do not develop a plan B where a potential risk of punishability would be an important factor. But also down the hierarchy, those conflicting rules and norms are of importance because if a soldier receives an order contrary to international humanitarian law, he will feel obliged to follow it because the order is given within his usual normative framework, even though it may be illegal. It's even possible that the ideology of a regime or enacted state law may be in contradiction with international humanitarian law. Even though legal innovation may be banned, for example, due to international customary law that is valid erga omnes, this may create a conflict of norms. And we have different rules claiming validity and legitimacy. Crimes in the field of international humanitarian law are mostly committed within organizational structures, such as the administration, the military, also enterprises, and there different actors may have very different insight and very different ideas about what they are actually doing. In human organizations, tasks are shared and distributed, and this leads to the fragmentation of individual contributions, of knowledge, and this leads to a dissolution of a sense of actual responsibility. Human organizations organize a responsibility. In Marxist theory, this could also be associated to the concept of alienation in the economical sense, but this is maybe also true to whatever relation we have between actors and things they are doing. So, leaders often act out of conviction, and direct perpetrators are part of organizations subject to command chains. Those will usually claim that they have to follow orders. They will further argue that their own role is limited anyway because they could be easily replaced by others. Even though in international criminal law the scope of application of those arguments has been drastically reduced to a few exceptional cases, the execution of orders will not exclude punishment, but nevertheless, most subordinates will consider orders as binding and follow them without further reflection, because the way they act is very much shaped by situative factors, such as what one could call a referential frame of war. The past, but also experiments such as the famous Milgram experiment, have shown that through the assertion of authority and coherent, more or less satisfactory explanations and narratives, men can be motivated to commit acts they would have considered completely unthinkable beforehand. And they will not usually feel very much responsible for what they have been doing. In war crimes, there are further factors. Very often, those in the field, the soldiers, act with very limited knowledge of the facts, but maybe also with relatively limited knowledge on international humanitarian law. If soldiers are poorly instructed, or if their instructions are even biased, then there is a heightened risk of the commission of war crimes. And also in the field, very often war crimes are committed under conditions of fragmented, incomplete informations and under conditions of personal danger. So if people are in the field, they will have very limited time to actually assess the legality of their actions, because if they reflect for too long, then probably things might happen that are detrimental to the goals of war, to themselves, or also to their comrades. It should be noted further that today the overall risk of conviction in international criminal law remains limited because the application of international criminal law, but also cooperation with international criminal courts, depends widely on states. And states are still able to shield their leaders, their soldiers, their administrations, as long as a specific regime is in power. And then there is still a certain mechanism of selection in place, because international humanitarian law violations are often committed by large numbers of perpetrators against large numbers of victims. And this nature of mass crimes makes selectivity probably unavoidable, even though the gravity of those crimes actually would call for a more complete legal answer. I wouldn't say that there is no deterrent effect at all. There are certainly some situations where people calculate the potential consequences of their actions, but as a whole, the idea of deterrence should not be taken as a reference for the creation and application of rules of criminal law. It does not seem wise to measure the effectiveness of criminal law with the idea of deterrence, and it wouldn't be wise either to try to enhance its application by introducing more crimes or more severe sanctions. So if deterrence doesn't actually work, what would be the actual functionality of international criminal law? That deterrence doesn't work would certainly not mean that international criminal law or international humanitarian law becomes useless. We still have functionality in the regulation of the administration of sanctions to specific breaches of the law according to specific procedural rules. Criminal law regulates symbolic reactions to past wrongdoing. It, in a certain way, collectivizes revenge and works as an instrument for regulating or for managing potentially collective emotions such as vengefulness. This has first and foremost probably a mitigating effect, as revenge is limited to crimes and sanctions previously determined by the law. This makes collective reactions to wrongdoing more foreseeable for perpetrators, and it also takes away the burden of standing up for specific rules from individual citizens, such as, for example, the victims or victimized community. And even though individuals, victims, and the media might be unhappy with the outcome of procedures in specific cases, this may in particular apply to acquittals, fundamental opposition to the system as a whole is scarce, and so would be individual acts of revenge against presumed perpetrators. Criminal law removes the potential social conflict between individuals or groups from the communities directly concerned and deal with it in a neutral, technicist manner. The conflict is cooled down and dealt with collectively by criminal procedure and criminal sanctions. The enactment and application of criminal law rules also asserts which rules and values are as important to society that breaking those rules will not remain without an answer. And this could also be described as the concept of positive general prevention. This, however, depends on the reliability and the perception of reliability of the system as a whole, as being an unbiased system. Here in politics, media and civil society, international criminal law is often portrayed as some kind of fight against impunity. This is a risky perception because it entails the idea that you already know the bad guys and just need to convict them. And in such a vision, acquittals would be a defeat of international criminal justice. But to criminal procedure, the openness of the fact-finding process and the real possibility of an acquittal is something vital. It's a sign of vitality and reliability of criminal procedures that acquittals remain possible. So, what next? How should we deal with a criminal law system, international criminal law, that actually does not prevent, that does not directly deter, that does not directly maybe influence peace negotiations? Well, probably it's important to follow a realistic and pragmatic approach. Even if we have to acknowledge that the international criminal law usually won't have any noticeable influence on ongoing conflicts, and there always will be situations where breaches of international humanitarian law occur and will lead to immediate military gains. In a broader perspective, those gains will be tainted with their illegality. Even if there is no or just a very low risk of prosecution for perpetrators, their acts will, at least in the wrong one, be appreciated in the light of international humanitarian law and international criminal law. So the rules of international humanitarian law still have the potential to unite the international community and create some kind of solidarity with the victims of violations of those rules. It's much harder to take the side of someone deliberately breaking rules of international humanitarian law because those rules frame communication on acts of war and gains obtained in armed conflict. The rules of international humanitarian law frame the discussion about warfare and also the perception of acts of war in the past. The mere existence of those rules makes it less attractive to take the stance in favor of breaking them, even if it might seem effective from a military point of view. So, even if the effects of international humanitarian law are not immediate, as societies and also as lawyers, witnessing war and breaches of international humanitarian law, we need to be on our guards and patient at the same time. It's vital that evidence is collected as early, impartially, and professionally as possible to make sure the factual foundations for trials are ready when needed. But we need to do this in the knowledge that some trials may never take place and others will only be possible after a very long time, as communities directly involved may not be interested in legal proceedings and in achieving accountability for quite some time, and the insight into the necessity for criminal procedures and accountability may only develop after some time and maybe after regime change. So even though the effects or the existence and application of international criminal law are not immediate, international criminal law is not completely ineffective in the long run. International criminal law shapes communication in the field of armed conflict and offers options for holding perpetrators accountable. Thank you very much for your attention.